Good morning, everyone. I'm Patty Engel, and we're here today. Chrissy Hamill and I are here today to give the legal update. We enjoyed presenting at this group, and as we've done in the past, I'd like to ask questions as we go along. We like an interactive session here. So Chrissy and I have 4 issues that we've divided up. The first one is the limited scope representation, and there's a handout in your materials on this. Limited scope representation. So it's where a person or a business decides to hire an attorney for a smaller part than, or just a portion of the entire case. This is also called unbundled legal service. And I would say what drives this is generally, in my opinion, is a client who feels they can represent themselves on all but maybe a particular issue, or maybe they don't understand a particular item that they would like the attorney to either behind the scenes give them some information on, or represent them in court on a limited basis. This obviously helps the client save money. What is important is the attorney must determine that it's reasonable to take on this limited representation. In other words, that the case is amenable to be carved out into this smaller issue, limited issue. It can be done at various stages. For mediation, I have seen it done pre-mediation, so a client wants to understand what the scope of the issues and how might I proceed in mediation. It might occur during a mediation or simultaneous with the mediation, particularly if it's a multiple day mediation, where they might confer with an attorney outside of the mediation about a particular issue that's arisen. And I don't know if that's happened in school matters, where sometimes you'll get a call, like we're in the hallway in a mediation and a question arises.
It does often come up. I represent solely school districts, and so I'm providing sort of the guidance through the lens of being a school district attorney, and it happens quite frequently. And generally speaking, the districts are familiar with the parents, or at least someone at the district, whether it be a principal or a teacher, is familiar enough with the parents to know perhaps what that parent's level of understanding of the law is in general. And so you have a good sense as to when there is an attorney advising on the other side. And so oftentimes, as Patty said, I get calls in the midst of mediation from a district saying, I think we have legal counsel involved, wanting me to confer, as the parents kind of doing the same thing. But it does come up relatively frequently, I think.
And I think it's a little easier on the school side because there's an ongoing relationship there. So Chrissy has the background knowledge of the district and how they generally operate. It's a little more difficult. It'd be very difficult for a person to call me up out of the blue and say, I'm in the middle of a mediation. What should I do? I mean, that's when I'm talking about, is this amenable to be carving out? Is this reasonable under the circumstances? And in Wisconsin, we have very specific requirements about how do we take on this limited scope representation. So we need to establish an agreement. The client needs to understand what is the scope of the work that I'm doing and what am I not doing for them under this agreement. and we call that informed consent. So it wouldn't, I can't imagine a circumstance that someone would call me up in the middle of a mediation if we have no relationship. But I have done it on the front end, and I've done it on the back end, where someone will call me up after the mediation has occurred, and they want to understand what is this agreement that we've prepared, and now they want me to, I'm going to sign this. Now, I need to be very careful about that. I can explain what's the written word mean, but I don't have the background information to say, is this good for you or not? So that's what makes limited scope a little tricky. But as I mentioned, the benefit of a limited scope is that the client can pay for only the services they need and not the full range. So it is encouraged under the law so that more people can have legal representation. And truthfully, oh, I'm sorry, sure.
Last night we were talking about templates, agreement templates, and how some of the school districts are wanting to use more of that with waivers in them. Would that be an area where this limited scope consultation might be helpful to families?
Yes.
Because it's predetermined legal words that parents would have a hard time understanding, I think, as we talked about last night. So that might be an area where they might use this limited scope.
Right, and that's where I have done these on occasion, where my role is to explain what all this means so that they can understand, yes, that is in fact what I want to have happen. I mentioned the benefits, less work and time commitment for the attorney, and that sometimes can be helpful if an attorney's busy, that, okay, I can take this on in this limited capacity. I also thought it might be helpful for the attorney who's working for the district to know that there has been someone else explaining, giving some more information to this family. Chrissy, I don't know what you thought about
No,
my
I absolutely
paragraph
think
there.
it's always beneficial from the district perspective to have somebody that is assisting the family with understanding what that agreement means. If not, I know sometimes I get the side eye from those who are serving as the LEA for the district when I can't provide guidance and counsel to the parent, but when I at least try to explain to the parent, okay, these are legal terms, kind of in a nutshell, this is what this section means. It might be beneficial for you to have your own legal counsel review it. Again, I kind of get the side eye from district staff when I do that, but it's a way to protect the agreement itself, the terms that the parties have agreed to, by ensuring that the parent really truly does understand what they're signing off on, what rights they may be releasing by virtue of signing off on that agreement. So it's always helpful to have legal counsel assisting with the parent, and if not, at least I can try to provide sort of a very plain language explanation of what those particular clauses mean.
Yes.
Do you both think that either party has a right to know the other party is maybe consulting with somebody on the phone during the mediation?
I think best practice, as we just discussed, it's helpful to know. I would tell you that in the statute, if it is a litigation matter, if it's a court matter, that's required. There are notice requirements that there is an attorney on the other side, and for what purpose, and when the attorney ends the representation. One other item that is required is if the attorney is going to draft something in that litigation area, they need to disclose that that this was written with assistance of counsel. But that's not what we have here, so I don't think that the law says that that must occur. But like I said, I think we, generally, we appreciate having an attorney on the other side.
It's one that's, which happens relatively frequently when the district doesn't have the attorney there, but then it comes to my attention that they're talking to the attorney.
Well, I'm going to tell you for trust purposes, the family, it would be better if the family knew that. I think in most cases, when I'm going to mediation, trust is has been diminished, and this would further erode it if family finds out that, oh, well, you can afford an attorney and you're not even telling us that you're sneaking around having an attorney involved. Jane?
It happens the other way too.
Oh.
So one reason why I
Fair
thought
enough.
this would be good to talk about it is because there was mediation that happened where the district attorney thought that the parents were represented, but the parent wouldn't say yes or no.
I agree fully. It goes both ways. For that trust component, my suggestion would be disclosure.
I would agree too, and I think, I always tell districts that I work with that it's not a secret that they're using legal counsel. There's no reason to keep it a secret. They have nothing to hide. And sometimes maybe it could be helpful to mention to the parent or mention to the mediator that can then be relayed to the parent that, district did consult with legal counsel on this to ensure that, we're well within the parameters of the law, or it's the district's position based on conversation with legal counsel. And I think it also then triggers to the parent or the family that if the district is utilizing legal counsel, that perhaps this might be an area where the parent might want some assistance, whether it be through an advocate or legal counsel as well.
Sure.
Other question, Patty?
Oh,
Yeah, my experience has been common for districts to ask if the parents are going to have legal representation. And they will say, doesn't necessarily mean we're going to have legal representation, but we'd like to know that. Let's talk to our lawyer and see if we really want to bring our attorney.
sure. But Jane, isn't that a pretty typical question that comes out? Who's coming?
It is, but in this case that I'm referring to, that kind of sparked my interest in this area, is the parent would say, I'd say, are you thinking about my question is usually, are you thinking about bringing an attorney or an advocate or a support person to the mediation? And they would say, we're not at this time thinking about bringing someone. And then the attorney for the district was that, I think they have an attorney and they're not disclosing. So I kept thinking of different ways to ask the question, and they dodged it each time. And then they went to mediation and they came up with an agreement, and then the district felt like they showed it to an attorney, and then there was buyer's remorse and they had to come back to mediation. So it seemed like there was someone participating that wasn't being disclosed.
Sure. And as I was thinking of the pitfalls, I was thinking that that would be one of them, not only confusion, but delay and very inefficient. If at the end of all this hard work, now we're going to have a person who wasn't even at the mediation weigh in, that just isn't a good scenario, and it's not a good foot to go forward on, for the school and the family.
So Patty, do you presume that the district represented in all the cases that you have? I mean, you make an assumption that they probably are. I mean, have legal counsel for a lot of other matters, so.
Right, and usually that is an early question I ask, because we often work behind the scenes in advance of a mediation to discuss and find out positions and so on. So that's a standard question for me.
So for Patty and for Jane, under the guise of limited scope representation, for the parent, having that legal counsel off to the side in the background, is that a possible cost-saving maneuver? for the
Yes, I would say in my mind, it's the biggest reason why a party would opt for limited scope. they only have to pay for that portion. But a pitfall, it's important that the client give all the necessary information so that I can give you a reasoned opinion on the issue. That is, for me, two pitfalls. The two biggest dangers are not having all the information, so I can't give the best opinion that I'm capable of, and therefore the client's not getting the best information. And the other is the potential for confusion. So you need to be very careful as the attorney to talk, I mentioned that informed consent, to really talk about what's the scope of this representation, what are we not doing, getting it in writing and signed by the client, because there could be confusion down the road. Oh, I thought you were handling that. You know, so that to me are the biggest concerns. Chrissy, any other concerns or benefits you see?
I think you've covered most of them pretty well. Oh,
Oh.
It sounds like if push comes to shove, though, there's nothing requiring either party to say they've got this partial.
I think it would come, okay, so if it's on the front end, if I am explaining the mediation process and they say, okay, I've got this, thank you, I'm on my own, there'd be no real reason, and I don't think I'm interrupting anything. If it's in the middle, just the logistics of someone excusing themselves to go take a call, and then all of a sudden, the tone changes, or that's a hint, like, what just happened here?
I mean, as a mediator, I can't say, I mean, I would say, I need to disclose this to the other side, or is there anything that, can they say, no, we don't want you to? They can.
Yeah, I think they can. And then at the end, I think it would also be made apparent when they don't want to sign at the meeting and they say, I have to think about this. Uh-oh, you know what, and the delay that it might cause. And then if they come back and want to renegotiate, to me, that'd be the worst of it. Yes?
Same question as Kay, I think, but just in a different form. Do you understand that the fact of representation is a confidential matter? So, you know, if a parent said to me, for example, I did talk with an attorney before the session today, and, you know, some of what I understand is based on that, but I would ask you, for whatever reason, and I can think of a couple, to not disclose that. I mean, I think the fact of representation is confidential.
I mean, I think if the parent says, I'm disclosing something, but I don't want you to tell the other side,
Take it personally.
yeah. But I would also, as I mentioned, I would think that to explain to them the benefits of that disclosure, or to try to understand, can you tell me, you know, why? And that's where you all come in your skill set of getting, having a dialogue about that. Okay, so this is just issue one, so now we're going to go on to the next issue.
I do just want to give a little context. So of the cases that we know have had attorneys in them, and this statistic has stayed pretty strong over the last 5 to 7 years, about only 30% of our cases have attorneys for school districts, and about 15 to 20 have attorneys for parents. So obviously, parents aren't bringing attorneys when districts don't have them. And in those 10 to 15% of cases where districts have an attorney and parents don't, a lot of those have advocates, non-attorney advocates. And the agreement rate is very high. It's about in the 90th percentile. Obviously, we can't track the cases that we don't know attorneys are involved. But I just thought that might help with, so you know how many cases do have attorneys.
So, if I understand correctly, in terms of agreement, it doesn't matter.
No, it doesn't seem seem to, but that's a testament to all of you as well.
Right.
When you say only 30% of the districts have attorneys, do you mean at mediation?
Yeah, 30%
Okay.
of the cases that go to mediation, districts have attorneys. Sorry if I didn't say that right.
We always thought that mediators, that whether there are attorneys or not, the agreement rate is the same. So the mediator is running the show, not the attorney.
I think that's probably a fair statement, yes, that the mediator is running the show. And if you do your jobs to the best of your abilities, I think regardless of whether or not there's representation on the part of the parent or the school district, they are able to come to a resolution. And you know, I am involved in several mediations, but I think I'd even be hard pressed to say that 50% of the mediations that my school district clients do, I am involved in. And that's oftentimes because if parent doesn't have counsel, I will never appear at a mediation if the parent doesn't have their legal counsel present. And so you're right, it's a testament to what you do that the parties are able to come to consensus even without legal counsel being there.
But when you don't appear at the mediation, you still may be advising the district.
I may be. In generally speaking, I'm advising on the front end prior to mediation ever taking place. I do receive calls occasionally during mediation, and oftentimes I feel when I receive those calls, those are generally the cases where the mediation process is probably already broken down and an agreement is not likely, such that whatever I am advising the district is not that linchpin that is ultimately helping to reach consensus. Was there another question?
Well, I was just going to say that in Minnesota, they, in the past, found a very large difference, but probably because by the time the family hires an attorney, it's a much harder case. It's festered for a long time, they're polarized, et cetera, so it's not because of the attorneys, it's just the opposite.
Sure. Any other questions on that topic? If you think of them, don't hesitate to ask. I always have this motto when I give presentations that no question is a dumb question unless more than 2 people in the room laugh. And generally that never happens. I have never had anyone ask a question where I've had like the room laugh. So that tells me that all the questions that you're presenting to us are good questions. We haven't heard any laughter on the questions, so fire away if they come up. Sure.
So when you get those on-the-spot calls from the district and the mediation is already in motion, how do you handle the conversation between you and the district in terms of disclosing those conversations to the other party?
Frankly, I don't know if I have ever been asked when I'm on a call about whether or not to disclose it to the other party. I'm trying to think of the times I've had calls. Oftentimes my discussion with the district representative is generally, this is something you might want to mention to the mediator. And so I don't think that I have ever had that discussion about disclosure of our conversation. The fact that legal counsel was represented, I don't think I've ever had that discussion with a client, that it should be disclosed.
Let me put it another way. What's your thought on the disclosure?
My thought on the discussion is I would not have any issue with the district representative disclosing that to the mediator. And I'm not thinking of a situation off the top of my head where I would have had a concern with mediator then relaying that fact to the parent. The district did have a conversation with legal counsel and receive some advice and input on this. I don't think I would have an issue with that being disclosed to the parent. Now I say that, I can't, like I said, I can't think of a situation off the top of my head where I might be opposed to it. But again, I always tell districts, if you don't have anything to hide, and to Patty's point, why not be transparent? Why not try to build that trust, establish that rapport with the family? I mean, I know a lot of times attorneys can be seen as adversaries, and there certainly are some, pit bulls that want to just kind of go at the other side, but really we're here to work together to try to find the best possible solution that's in the best interest of that kiddo. And so if that's what our focus is, it doesn't matter to me that parent is aware of my presence or my conversation with the district. This was our short
issue.
issue.
We have 3 more to go, guys. So you don't.
On another roster, parties will show up with attorneys, an attorney, the other party does not have the attorney, and what I observe is that the attorney does show up, will ask directly, ask the other party, are you represented? And the party will say, well, actually, yes. And then the attorney will say, I need to stop the mediation, I need to get on the phone to ask your counsel if it's okay if I speak directly to you.
Mm-hmm. And that's because of our ethical responsibilities as legal counsel in terms of we are not allowed as legal counsel to interact and have those discussions with a client who's represented unless there's been that authorization or that authority given by the opposing individual's attorney that I can have those communications directly with that individual. And especially in the case of a parent, if the parent is represented and they disclose that fact to me, I want to ensure that I'm on the phone with Patty or whatever other attorney is representing the parent so that Patty's aware that her client has shown up without legal counsel or that I'm interacting with her client, and to ensure that Patty's okay with that. And if Patty is not okay with that, I'm not moving forward with any further discussions with that individual. Now, districts don't, and I say don't, they shouldn't bring legal counsel to a mediation unless parent is also bringing legal counsel to the mediation, unless there's been some type of understanding that that is taking place.
Oh, in a perfect world.
Right.
I think sometimes when I've been in mediation, like for instance, it's happened probably more frequently that the district seems like they are just not really engaging and trying to do some things that are probably not appropriate. And I will ask in private session whether they've consulted with their attorney about it.
Mm-hmm.
And sometimes that's a way to move them because they really haven't. And then when they talk to their attorney, they say, no, you can't do that. You know, kind of thing. And that helps to move along sometimes.
Sure. I've had that happen as well, many times, probably more times than I care to admit. Okay, so we'll switch gears and we'll talk about residency. I practice in the Milwaukee area primarily. I do have clients kind of scattered throughout the state, but primarily in the metro Milwaukee area. And so residency is always a big issue in that area. And in the rule that applies is this Thayer rule that came from a case dating back to 1889. And the rule is still good. It's still the rule in the state of Wisconsin, and that is that a child is the resident of the district where he or she lives, regardless of where his or her parent lives, unless the child is there solely for the purpose of education. And so, this is generally pretty easy in terms of students. They reside in the district with one or both of their parents. They're a resident of that district. Residency, not an issue. Becomes tricky where there's those situations where perhaps broken families, guardians are involved, foster parent situations. On any given day, I think I probably receive calls about residency and what the status of a student is. It's somewhat ironic to me that I've reached out to DPI on this issue a number of times just to kind of talk through things, and DPI's answer is kind of always the same. We stay away from residency. That's a local issue. That's a school district concern. And it really is. And so school districts, I feel, have a lot of kind of flexibility in terms of how they interpret residency concerns. The special situations that I often see that are often problematic are those that are bullet pointed in your outline. The pupil resides with someone other than the parent. The question is then, what is that someone's legal status? Why is the student residing with that individual? What is the purpose of that situation? Again, in the Metro Milwaukee area, oftentimes I'm finding that the reason that student is residing with the aunt or the grandma or a family friend is solely because that family wants that child in that particular school district. They're residents of Milwaukee County. They don't want their child in the MPS school district, so they've sent them to live with aunt or friend in the New Berlin school district, so that child can go to school at New Berlin. In those types of situations, if we look at the Thayer rule, what the definition of residency is, those students don't qualify as residents of that district. They're only there for educational purposes. Flip that with the situations where you have a student who, whose parent is unable to provide for that child's needs. There perhaps is a guardianship order in place by the courts, or there's a power of attorney situation where a parent has signed their rights for any number of things, perhaps even including educational decision-making, over to another individual through a power of attorney. Those are situations where, based on that legal status, there's been a legal document that's assigning guardianship to another individual. There's a power of attorney in place where a parent has said, I'm giving my rights to another individual to make those decisions for my child. In those situations, that child then likely is a resident of that other district. The child's residing with their guardian, residing with that power of attorney. That student then legally would be entitled to receive an education in that district. Question?
District have the right to look behind that agreement?
Again, it's a matter of local control, and so a lot of districts do have policies that indicate that they have the ability to independently investigate any residency issues that they may feel arise. And so a lot of the districts I work with, I encourage them to have that policy, only because, unfortunately, again, in the metro area, there are a number of parents who do try to work the system and to get their kids in a different district. And so a lot of districts do undertake pretty significant investigations into the actual legal status of a student. I have had districts that hire private investigators to sit outside the home of a student or where that student is allegedly residing to determine, is that student there ever? Is mail going to that student's home? Schools may sometimes send a direct mailing to the home to see if anybody ever picks up that piece of mail. If that mail is never picked up, pretty good indication that perhaps that student is not living there. So, you know, to your point, do districts have the right to conduct an investigation? Absolutely, they do, but I think it's best if they have it in a policy, so there is that clear direction as to families that districts will undertake that.
In the case of the program that you mentioned earlier, even though it will be the ultimate goal of the family for the kid to move there for education purposes, but that's not what they say. How do you determine the ultimate reason?
That's where they hire investigators and do investigations to determine what is the purpose. Because parents will always say, or at least I have found, parents will always say it's not solely for education. Sometimes it's parents' job. In those situations, maybe it's a closer call where a student has to reside in another district because mom or dad work third shift and it's just not feasible for the child to be living in the home with the parent. But ultimately, that's where my advice to the district is investigate it, gather some more information to make that residency determination. Another situation where this often comes up is with respect to homeless students. With respect to homeless students, the federal McKinney-Vento Act applies, which looks at whether or not the child has a fixed, regular, and adequate nighttime residence. Those terms, of course, have all been defined under the law, out of case law that has developed. And so you look at, does this child have a regular and adequate nighttime residence in your particular district, and if they do, they're likely not deemed to be homeless. If they don't have that regular fixed nighttime residence, they might be deemed to be a homeless student, such that what we call a school of origin analysis will come into play, where you look at where was that child last enrolled. And so if you're dealing with a homeless student who lacks that adequate fixed regular nighttime residence, where was that child last enrolled? That is likely that child's residence district for purposes of attending school. The analysis is rather tricky. It's not something that we necessarily see a lot of, and I think from the perspective of districts I work with, oftentimes we don't see a lot of it because districts are cognizant of the circumstances of the child, and they know they want to do what's in the best interest of that kiddo. And so if you have a child that's maybe bouncing around from home to home, districts are cognizant of that and will keep the child in that school, the school of origin, regardless of perhaps where they are bouncing to and from.
Is a hotel considered a fixed and regular residence?
Generally speaking, a hotel isn't, it depends, I would say, on the particular parameters of that hotel stay. I think in a lot of instances it probably is not, because of the possibility that at any point in time it's no longer going to become fixed. But I think it really depends on more factors than just they're living in a hotel. Question?
Is a homeless shelter considered that? If someone's staying in a homeless shelter for a lengthy period of time?
That child, by virtue of the fact that they're living in the homeless shelter, again, maybe they're staying there for a period of time, but we don't know how long that period of time is going to last, such that a homeless shelter probably is not going to be that adequate regular nighttime residence. The homelessness determination or that analysis applies to transitional housing, so that homeless shelter type of situation. It also applies to kids who move in with relatives. So you may have a student who is moving in with grandma, and absent any guardianship agreement or a power of attorney agreement, that student may be deemed a homeless student by virtue of the fact that mom and dad are unable to provide that regular fixed nighttime residence. And so that's a consideration that you would have to look at as well with respect to a homeless determination. I'm sorry.
So if they're determined homeless, then that district has to serve them?
If the student's determined to be homeless, and they're in District A, and student's determined to be homeless, and perhaps student then moves into District B by virtue of the fact that they don't have that regular fixed nighttime residence, School District A is going to be considered the school of origin for that student, and as school of origin, that district would then have the responsibility to educate that student.
And provide transportation.
Correct, and provide transportation.
But this is all up to the individual district as to whether or not they're going to bother to follow up on the 1889 daily rule, whatever it is. So they can accept the student without having to do that.
Correct.
Make that decision.
Correct. Other situations where this comes into play as well are foster situations. And in foster situations, under the Every Student Succeeds Act, we look at school of origin. Where is it that child was attending school? And generally speaking, there's going to be a best interest of the child determination as to, yes, we had a student that was in school district A. They've now been placed out of home in a foster home in school district B. Is it in the best interest of the child to continue to attend school in school district A, or is it in the child's best interest to attend school district B? That decision is going to be made collectively by both the school district, the foster family, the county caseworkers that are assigned to the case, and that decision will be made by all the parties getting together in the room and determining what is in the best interest of this kiddo who's now in the foster program.
Does the new school district participate in that process?
Yes. Very good point, thank you. Other unique situations that maybe come up are when you have a parent who's incarcerated, where the parent still does have their educational decision-making authority. They still have custody of the child. For all intents and purposes, they still are the one who is to be looking after the child, but by virtue of their incarceration, that student has now been placed with a family member or another family while the parent is incarcerated. Again, you have to make that residency determination. Why is it that the student is living with that, in that family situation that they're living in? But that's an issue that I've seen come up as well. Another interesting situation that I've had come up, unfortunately, several times is in the case of two divorced parents, and you might see this in mediation as well, where you're dealing with the separated homes, where dad lives in school district A, wants child attending school in school district A, mom lives in school district B, mom wants child attending school in school district B. Who's right? According to DPI, when I've consulted DPI, they have said that technically the student, if they're residing in both A and B school districts, has the right to attend school, both in school district A and school district B. So you create a situation where on Monday, Wednesday, and Fridays, student is attending school in school district A. On Tuesdays and Thursdays, student is attending school in school district B. School districts always tell me, well, that's not right, you can't do that, you can't have a student, they have to choose which district they're enrolled in, but technically the student can be enrolled in both school districts. And so that creates, I think, issues for you as mediators if you have parents who are coming to the table who just can't seem to get along and are both making different demands based on the school district that they want the student to be in. It's a very tricky situation, and anytime I get these calls, I kind of throw up my hands and say, what are they doing? This definitely isn't in the best interest of their child. Why are they putting their child through this? But nevertheless, I'm sure you've probably all seen situations where that has come into play, and the only advice I can give you is to try to get the parents to understand that this is the detrimental impacts that this is going to have on the child by being split between two different school districts, and how you can maybe help bridge the gap between those parents before you try to bridge the gap between the school district and the family as far as whatever the issue is on the table for mediation.
And Chrissy, would you say that occurs when there is an even split of the time the child spends with each family, when it's truly a 50-50
Yes,
split?
that's generally when we see that issue come up, is when it's the true 50-50 split.
Is there a situation where get back to your Berlin situation, where the parents live separately for the purpose of selecting a school district that the district in which the parent is living and the student is going to school can seek contribution from the other district or the other parent lives? Have you ever seen that, or has anybody ever tried to do that?
I don't know that I have ever seen that as far as school districts seeking contribution,
I
where,
remember a case that I had where the district was really upset about the fact that the parent had moved into the district. The other parent was back in the home district.
I mean, I have advised districts where parents try to pull a fast one over on the district and, move into a one-bedroom apartment with their 5 kids for purposes of attending school in that district. I've advised districts that, well, if the parent truly wants to do that, we have enough evidence to demonstrate that it is solely for educational purposes, tell that parent that they then need to pay the tuition for their child to attend school in your district. And given what that tuition cost is, most parents generally say, okay, fine, we'll go back to our district and we'll try and figure out a different way to work the system and get our kid into your school district. I will tell you, I don't necessarily know if that position would fly in the courts, but I think that it's such a big cost to the district at times that it's not an untenable position for a district to take to say, we're going to charge tuition.
Is there a circumstance where if the parents are splitting the kid that is, and it's not beneficial to the child, or they're doing it just for residency purposes, where the school district can be the impetus for them going back to court to have that set out in amended divorce?
That's a very good question, and that's oftentimes what we will advise districts, even prior to a situation where it gets into mediation, is this isn't your problem as a school district, this is the parents' problem, and they need to work it out. And tell them to go to court, work out their issues however they need to, and then come back to you and tell you as a district what their decision is. But you're absolutely right. That's the best way to resolve that type of issue if they're not able to amicably agree on what the solution is, to go into court and get that determination from a judge as far as what that looks like. There are a number of other situations where residents generally rears its ugly head. I know this was kind of our second topic, and I want to make sure we get to all four. So if there aren't any other questions at the moment, you can always come talk with Patty or I after. But I'll move on to our next topic, which is going to be transgender students in the state of the law. I first started presenting on transgender student issues to various school district groups back in, I think it was 2015, when we were starting to see a lot more activity in courts and state agencies with respect to transgender students. And we were starting to see the law kind of develop in this area. I can tell you back in 2015, I would have had a different outlook as far as what might happen in the courts at the federal level under the prior administration than what I think the law might do under our current administration. And so it's an area that is still gray. I like to tell districts it's clear as mud, and do the best you can when you are faced with these issues. Now, that's really terrible legal advice and certainly isn't helpful for a lot of districts, which is oftentimes where we're looking at a lot of these situations on kind of case-by-case basis, which is where it comes into play, I think, with respect to special education students who perhaps have an IEP in place for a particular disability that may or may not be connected to the fact that the student is transitioning. As far as our current state of the law here in Wisconsin, there was a case that went up to the 7th Circuit, and it dates back to 2016. And the 7th Circuit encompasses the state of Wisconsin, so the guidance that comes out of the 7th Circuit, we can kind of hang our hat on as far as how courts might decide something here in Wisconsin if parties get to a point where it goes through the court system. And there, the 7th Circuit has recognized that it is likely, at least in this particular case with this student, based on the facts of the situation, that the student could claim that the district that could claim that he was protected by Title IX, which protects against sex discrimination, and that he has, or that he had an equal rights claim under the 14th Amendment. And so based on that, it looks like in the 7th Circuit anyway, and in Wisconsin, districts and parents would need to be mindful of the fact that it likely would happen where a student, if they are not adequately assisted with a school district with respect to their transition process, that if that claim were to go to the courts, the student would likely prevail. So what that means for school districts and how I advise districts is that you need to ensure that you are having discussions with that student to ensure that you are avoiding the potential for a discrimination or an equal protection claim by a student when you're dealing with a student who's transitioning.
Did they leave that sit, or did they try to appeal it?
So they did, so the district lost at the 7th Circuit. They were intending to appeal it. And after I believe they filed a writ to appeal it to the U.S. Supreme Court, and then the parties settled the case without going through the process. Settlements of that type are confidential, but from what we've heard, it was settled to the tune of about $800,000 that the district would have paid to the student.
This is just so this case is just a preliminary injunction?
Yes.
Not an actual?
Correct,
Okay.
correct. It was a preliminary injunction. That's why we don't necessarily have that clear guidance. It was just, the student had a likelihood of success with their claim. And then what we've seen in other courts across the nation, we've seen it trend in that direction. But again, our Supreme Court makeup is very conservative, and that's not changing anytime soon. And so I think that there's a greater potential that we might see some of these lower court decisions go the other direction. When I advise I'm sorry, go ahead.
So why are the districts not prevailing? Because they're not having those discussions?
Generally, they're not, so generally where we see districts not prevail is the issue of restrooms. Because all these other issues, and I have these areas of concerns that are noted, names and pronouns. It's very easy for a district to say, okay, we have a student that's transitioning. The student was Michael. The student now wants to be Chrissy. We'll go ahead and call Michael Chrissy. That's not an issue. That doesn't raise any concerns or tensions, generally speaking, with staff, with other students, or with the families of other students. When it comes to the restroom issue, when you tell a student, Michael, who's transitioning and wants to be called Chrissy, that he can now use the female restrooms, that's where you have concerns raised by other students, that a male is now using their restroom, that parents start to get a little bit concerned about the fact that their daughters are now having to use a restroom with a male, and it becomes a bigger sort of PR issue for the district than anything else. So in the situations where they're often, these matters are often going to the courts, it's on that restroom issue where Michael wants to use the women's restroom, district says no, we've got a staff restroom that is down the hall and around the corner, and you have to walk 3/4 of a mile to the restroom to use it. You can use that staff restroom versus using the other restrooms, and the students saying, no, that's discriminatory. So those are the cases that we're seeing trending in the courts, is on the restroom issue.
May I ask, does this apply for individuals who identify as transgender and not necessarily, there's no obligation for them to be in the process of transition? I would imagine that a 14-year-old legally probably cannot make that decision, right?
Well,
I don't know, well.
one of the things that, we don't necessarily have clarity at the courts, and I am not a medical doctor, I will not claim to be, but in terms of that transitioning process and what it means, it looks very different for a first grader versus that 14-year-old. And my understanding is that 14 or 15 might be the age where a child, an individual can actually start like hormone therapy if that's the route that they are intending to go. And so it would be very difficult, I think, for a district to prevail on a theory that, well, we don't have any documentation that this individual is actually medically transitioning, and that's a requirement of ours in order to treat the student as a transitioning student. I think a district would lose on that every time they would go to court if that was the requirement. And I don't see a lot of districts that are taking that type of position with respect to students who are transitioning.
So is your advice then that if they identify as transgender, is that, if someone maybe in second grade then says, I'm a girl.
My advice, so there's two lines of thought that I see with attorneys and risk management, insurance providers in the state of Wisconsin. One approach is have a policy, develop a policy that gives sort of bright line rules for how you're going to deal with these situations. I don't take that approach. Generally, I am a policy-based type of attorney that says policies are good, they provide guidance, but in these situations, because the law is so unsettled and you're looking at what is best for the child, I think the better approach is to deal with it for the time being until the law settles on a case-by-case basis. You have a student who comes to you, says they're transitioning as a school district, sit down with that student and determine how it is that the school district can support that student. What is the student needing from the district as the student is going through that process? Because from what I've found, it does look very different depending on the student, and it looks very different for a first grader versus the 14-year-old student, which brings up these areas of concerns that I've hit in your outline. And I put them in there just because they're things that schools and families, I think, need to think about as the student's transitioning. One of the pieces that I didn't necessarily put on here, but it kind of falls under the transition and support bullet point, is you have a student who's transitioning, and this is where these situations become tricky, where a student comes to maybe a counselor or principal at the school and indicates wanting to utilize that female restroom, but please don't tell my mom and dad because they don't know yet and they're opposed to it. How do you work with students who are in that particular situation? And those are tricky because all of the research on mental health issues show that students who are transitioning have increased rates of, being bullied, increased rates of anxiety, depression, increased rates of suicidal ideology. And so you're dealing with an even greater concern with respect to those students who are maybe dealing with issues where they're not being supported in the home and they're looking at the school district for support. Schools then also have a responsibility, of course, to communicate with parents about things that are happening in the school. So how do you deal with that dichotomy when you have a student who says, don't tell mom and dad, but you as a district generally have an obligation to talk with parents about things? I can't give you any advice with respect to how to address those issues, other than it really truly is a case-by-case analysis that I undertake with districts when they have those issues that come up. I think for purposes of you as mediators, have any of you seen transgender issues come up in your mediations? You may, and again, it's not the fact that a student is transitioning that's the disability. It's generally a disability somewhere else that maybe has an impact on the student as they're transitioning, or that transition process has created some of these underlying issues that result in a disability, where you might need supports that are built into the IEP to address the disability that also are going to address some of those concerns that you would have with a student going through the transition process.
Okay, this is a really basic question. So then if someone is being transgender, it's not considered a disability, or is or is not?
It is not a disability.
Okay.
Well, I shouldn't say that. Transgender status in and of itself isn't going to qualify a student for an IEP. It will be because of another disability that they have that would bring them under the umbrella.
And are there really common repeated mental health, or what are the things that you see?
What I've seen a lot is the anxiety, depression, and some of the behavioral issues that maybe come about as a result of the student really struggling with that transition process, where maybe an EBD disability identification comes about as the student is struggling with those issues.
So I guess I have a question, or a comment and then a question. So I'm an employment attorney, so I haven't
Sure.
dealt with this in mediation, but I've dealt with advising a lot of companies on transgender issues. And I would just second what you're saying about the case by case, because it is so particular. You can't really guess what someone is going to feel comfortable with or what they're really asking for. But I guess to go off Gia's question, it seems to me that just mediation in general would be a great avenue for working through all those issues, but would it qualify for special education mediation?
If they had an IEP. So
Only if they have an IEP though.
Yeah, I have had a few cases that I've talked about where the child is getting services, as Chrissy said, for EBD or other health impaired, for the anxiety and depression and mental health issues. But they can also have a physical disability, but it can't just be for the transgender issues.
I know I talked through that really, really fast and just gave you sort of the 30,000-foot level overview, but we have one last topic, and I want to make sure I give Patty a chance to speak because I feel like I've dominated the conversation. So again, if you have questions, feel free to catch me after.
Oh, good job, keeping us on track, so thank you. Okay, so last issue, this timing is perfect. The last issue is emotional support animal versus service animal. And in the past, we've talked service animal on several occasions. So the focus today is on emotional support animal. And those are two very different animals. And therefore, the recognized rights are very different as well. And it can be kind of confusing. So I'm hoping to clarify that today. So emotional support animal goes by a variety of names. Emotional support, a comfort dog, a therapy dog, a companion dog. And what they all have in common is that the animal provides a sense of well-being to a person by its very presence. Because it's there and because I can touch it, that helps me maybe regulate. Importantly, the emotional support animal is not trained to perform a task or do a job, and therefore it's not a service animal, and it does not come within the protections of Title II of the ADA. As opposed to a service animal, and I'll just touch on it real quickly. We've done this before, but a service animal is a dog individually trained to do work or perform tasks for the benefit of an individual with a disability. And a clarification, it can be a dog or a miniature horse. And the work or task that the,
Be a pig?
no.
I've had that question, okay.
Yep, nope, those are the only two when we're talking service animal. No, so all of that, people are asking pig, peacock, warthog, or, so that is all that we've heard from airlines, when the cockatoo shows up on the guy's shoulder. Fortunately, they've got a different law. We're not dealing with the, Aviation Carrier Act. We're dealing with Title II of the ADA. So dog individually trained, specifically trained to perform a task or a job, and that job is specifically related to the person's disability. Under that scenario, Title II of the ADA says a school district must make reasonable modifications in policies, practices, or procedures to allow service animals in order to avoid discrimination on the basis of disability, unless the school can show making that modification would fundamentally alter the nature of the program. That has been looked at as a pretty arduous task to do. A school just can't say, there are some kids that are afraid of dogs, or there's a child with an allergy. That's not fundamentally changing the program in most cases. So for a service animal, the sorts of things that a dog might do is, for like a student with autism, they might help prevent elopement, running off of school grounds, or self-harm, or mood swings. They might be trained to get on the student to calm them down. Same thing might help for children with emotional issues, that they can help them calm and be grounded, but only if they are trained to perform that task rather than just be available to be touched. And then, so I talk about a psychiatric service animal. And again, those are animals that have been specifically trained, so they are protected and fall within Title II of the ADA. Just want to briefly touch on, so what's the difference with an emotional support animal in a school and a service animal? Huge difference. So emotional support animal, the one that the presence is helpful, that student is not entitled to bring an emotional support animal to school by legal right. Title II does not apply, which prohibits discrimination. A student, however, that's not the end of the analysis, because a student may be allowed to bring an emotional support animal to school if it's needed in order for the district to provide a free, appropriate public education. So with an emotional support animal, we're talking going through the IEP team meeting and there being a discussion. I see the parent raising this, we would like to bring our emotional support animal, and I see the district saying either, sure, sounds good, let's talk about how we can make that happen, or them saying, no, that's not needed, we can provide FAPE in other ways. We don't need the dog in order to do that. And I see the parent having to defend that to show all those other options presented by the district would not, in fact, provide FAPE. So with an emotional support animal, the IEP team is of critical importance. Unlike the service animal, so that is where the specifically trained animal, the IEP team isn't really a factor. They're not going to undertake an analysis. The student is entitled to bring the service animal to school under Title II of the ADA. Of course, subject to the dog being, following all the obligations of having their vaccines, following state and local laws of having, being licensed, that the dog wouldn't be disruptive in school, it's not barking, it's in control of the handler, and the handler is generally the student. It is not school personnel. The person in charge of the dog is, for the care and supervision, is the student. Under those situations, it's not an issue of, is this dog necessary for FAPE? It's not an IEP team decision, and there's no need to discuss, would the district prefer other substitutes?
5 minutes.
I'm open for questions.
So, that definition sounds fairly clear.
Oh, good, but the application will get you every time, yeah.
So, what if my dog has been specifically trained? It's not really a service dog, but it's my comfort dog that's been trained to do X. Who makes that determination that really is a service animal as opposed to a comfort?
Well, if your dog has been specifically trained
By an accrediting organization?
or by you and your mom, but the dog has been trained to do a task that relates to your disability, then it is no longer an emotional support dog. It is, it is it's a service animal and entitled to protection. And there have been some cases on just that issue, that it kind of crossed over. Okay.
I know just a little bit about horses and miniature horses, and they can't be potty trained. How could you just bring a miniature horse into a class?
I didn't get into that level of detail of specifics, but I was very intrigued, and so I did a little more reading about it. And, it's like, why would you select a miniature horse? And you can probably, you can weigh in on this, but what the woman who uses this miniature horse said is a horse would be available for about 30 years, as opposed to a dog, like 5, 6, 7, and then we're looking for another. She also said, my miniature horse has never dragged me across the lawn chasing a squirrel or a rabbit, as opposed to my service animal that I've had. So I thought, oh, okay, there's some, so for cost purposes, for training purposes, but yes, she didn't go into that level of detail.
That would be the first thing that would occur to me. You just can't take this animal into a classroom and have it be there.
Well, then you couldn't, the animal must be, house trained.
There's no way to house train a horse.
A bag under the tail, my dear.
I have not seen a student or family that has requested a school to utilize a miniature horse. I don't know if you have, Patty.
No,
but,
no. That's why I needed to do a little more digging on it.
There's
Right.
not a lot of guidance out there
But
with
the
that.
longevity is
I mean, and that makes sense. She said that, we've got this rapport, and I don't have to, it's expensive to train, a dog, and then they only last 5 or 6 years. And she said the miniature horse is very docile, and, yeah. Kay. Okay.
Betty, I think your description of the distinction between emotional support and service animals are excellent. I think it clarifies what is needed for patients. One is ADA-driven responsibility. The potential dispute in school is, how do you define service animal? Does it have to have a license, a certificate? And this is where I think the question that was raised here is excellent, because it points out where dispute occurs. What does it take? Is there any clarification of the makeup of a license for service animals?
No,
Because there's certifying agencies, for.
there can be, but it's not
It's not
required.
Just briefly, if you have a student in the class who is allergic to dogs or horses, and then the student who wants the service animal, is it a
Balancing, and how can we accommodate both? Does the student maybe need to go into another classroom? How do we limit that exposure to the, well, that's exactly right.
Generally, it's the one with the asthma that gets moved, than the student who needs the service animal, which you can imagine how well that goes over with the parents of the student with asthma.
Okay, we're gonna take a break now for about 10 minutes or so, so thank you very much.
Thank you all for your.
Thank you.